All right, this is a case of the people of the state of Michigan versus Tony Lee Bennett, case number 25-551-SD. Appearances, counsel.
Brittany Lawrence on behalf of the people.
Robert Hartzell from Mr. Bennett joins me at the table, Your Honor.
All right. And we are here for a probation violation hearing on a violation that alleges that the defendant violated probation by testing positive for alcohol on December 22nd. Is there any resolution?
Yes, Your Honor. My client is in admissions.
All right, and just for the record, there is a prior violation that he acknowledged that he had consumed alcohol back on September 12th. Mr. Bennett, first of all, I guess Ms. Lawrence, any objection to a plea in this matter?
No, Your Honor.
All right. Mr. Bennett, Mr. Hartel says that you're going to admit responsibility for testing positive as alcohol for a probation violation. Is that accurate?
That is right.
Has anybody promised you anything in order to get you to plea?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plead?
No. That already is my choice, yes.
All right, counsel, are either of you aware of any promises, threats, or inducements not made part of the record?
No.
All right, then Mr. Bennett, will you please raise your right hand as best as you can? You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Then to the allegation that you of your probation by testing positive for alcohol on December 22nd, how do you plead? In order to accept that plea, I must have you tell me what it is that makes you guilty. So as a term of your probation, were you not to consume alcohol?
Yes.
And you knew you weren't to consume alcohol?
Yes, I knew that.
And sometime around December 22nd, had you consumed alcohol?
Yes.
And when had you consumed that?
When?
Yes.
22nd or the 21st around 10
All right.
p.m.
And what is it that you drank?
I drank a 2 glass, amounted to be about 1 large glass, 2 small glasses of wine.
Okay, and you knew it was wine? All right. Do counsel believe the defendant has provided a factual basis to accept the plea and the court rules have been complied with?
Yes.
Yes, Your Honor.
As does the court. I find the plea is knowing, voluntary, and accurate. Mr. Bennett, I find you guilty of a probation violation. By my count, this would be the second technical. Is that correct, Ms. Bismarck?
Yes. Yes, Your Honor.
All right. Has the parties received the recommendation in this case?
Yes, Your Honor.
Yes, Your Honor.
All right. Are there any corrections that need to be done to it?
No, Your Honor.
All right. Allocution, Mr. Hartel?
Yes, we would ask the court to adopt that recommendation. I did go over with my client. He does realize that he does have a problem. He does want to go to treatment. He does believe that's appropriate. I'm not sure if our office social worker, Brian Henniger at the defender's office, can help him with that or not. He mentioned he may have some issues with his insurance that may need to be repaired. He's not 100% sure on that. It may require some research, what I'm trying to get at. But his goal is still to get to that treatment to avoid this revolving door, this circle of issues, as we've seen in other cases as well. Definitely not just limited to this gentleman, but definitely including him. Drugs are bad. He's realizing that. He wants to help. I asked the court to adopt the recommendation and help himself. Thank you.
You said drugs are bad, but
Drugs and alcohol are both bad.
there we go.
Okay,
I thought you were trying to throw in something else there for us.
sorry, Your Honor.
Any allocution, Ms. Lawrence?
Your Honor, I would also ask the court to adopt the recommendation, although this is only the second technical. Reading the narrative on the recommendation, it sounds like in a general sense, he has not been doing very well on probation. So I would ask the court to adopt the 10 days jail as well as residential inpatient treatment.
Thank you. Mr. Bennett, you have the right to address the court before sentencing. Is there anything you'd like me to know?
Yes.
Go ahead.
Yes, Your Honor. I do plead guilty to the 2 counts. But it's been a bumpy road for everything to go for me. Coming right out of the door, I started running. I'm on several mental meds and several physical meds. Coming right out of the door, about a week to 10 days after, I started running out of the med scripts that I had in jail. And I tried to contact my primary doctor. And while I was in jail, they dropped me and they would not refill my scripts at all. You're talking a massive number of, like, I take almost 13 pills just to be dropped right off. My body was going through quite a bit. On that note, I did go see one other doctor. I found out he wasn't going to help me very well, so I set up an appointment with another one. Now that appointment is January 5th. If released today, I would like to maintain that appointment so I can try to establish my patients before I do go to rehab, if you choose for me to go to rehab. And so I could establish at least a little bit of a relationship with my work before I go to rehab. On a larger footnote, I wasn't ordered to seek further help other than CHS. I was sentenced on the 10th of September, but I did further get into conversations with CHS, and they were very helpful and very influential. And we stumbled across the conversation about me asking them what they would think about me going and getting psychological help from a psychologist to help with some of my mental disorders. Like, for one, I am post-traumatic stress syndrome, but I'm a depression drinker. And without all my meds, that also did not help. But I was seeking the help to get that treatment. I've never been treated for PTSD or anything like that. I wanted to get the involved and try to help it right from the get-go so I could stop the drinking completely. What had happened, I should have already been in rehab, or should have already started my treatment with a psychologist at the beginning of September, beginning of December. But when I had got my job at Hutcherson's, I called DHS and told them they can drop the food program. I have a job, but I'm gonna need the insurance until the first of the year, because that's when my insurance kicked in from my work. They dropped my insurance on December 1st. So I lost communications with Catholic Human Resources, which I was trying to restore they were helping me restore Medicaid again on the first of the year. And that got actually put back in jail. I was supposed to meet with them. It never happened. So if you do choose to release me, I would like to maintain that doctor's office appointment so I can get my meds taken care of. And when I go to rehab, I will be in my proper state of mind.
I'm sorry, what's your doctor's appointment again?
My appointment, January 5th, Monday.
Okay. All right, anything else you'd like me to know?
I did, Judge, thank you. Yes, there was one thing. I did keep Miss Bismarck informed the entire time
Informed of?
of the whole situation, the meds being dropped. I stayed in contact.
Ms. Bismack, I can't seem to put my hands on my copy of the substance use assessment. Do you have a copy in your file?
I do.
How did he test?
He identifies with alcohol use disorder severe.
Okay, thank you. I am going to follow the recommendation in this case. I believe it is appropriate. So I'm going to continue probation with the following conditions. There is 10 days jail, 8 days credit, and defendant must attend inpatient treatment. Anything else, counsel?
No, thank you.
Mr. Bennett, best of luck to you. Thank you.
They're still.
Kevin Peterson?
Quicker than I thought, Kevin, I'm sorry. It's quicker than I thought. Dragging me in here.
All right, this is the people of the state of Michigan versus Kevin Lee Peterson, case number 255150 FY. Appearances, counsel?
Joanna Carey for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Peterson. He's joined me at the table.
And we are here for a probable cause conference. Is there any resolution in this matter?
There is not, but there is an active negotiation to the extent that we don't have the labs on the felony drunk driving charge or OUID charge. So I would intend to waive the 21 days with the PCC. Our intent, quite frankly, is to bring it back to you as a complete package as soon as we can. We just can't do it today.
Sure.
Oh, that's right.
Yes.
There's arraignment as well.
I arraigned him on the 22nd on an amended complaint.
Amended the complaint, a second amended yesterday.
We don't-
Count 1 to possession of cocaine.
We don't have that.
Unless it's MSP and we have MSP coming in right now. He has it.
It is his MSP.
Okay, they're coming in right now, so they might have it.
Let's wait a minute then, if you want to take Mr. Peterson back, and we'll see what happens. All right, we are back on the record in the people of the state of Michigan versus Kevin Lee Peterson, case number 25-5150 FY. We'll just go ahead and do the PCC right now, and then we can do an arraignment on an amended complaint later on. So I think we left off that we were waiting for labs. Mr. Harrison, you'd indicated you were going to waive the 21 days.
I did, and I believe I checked that box on the form as well.
You did. Any objection to that, Ms. Carey?
No.
We want to set this one out then to the 20th as well, give the lab some time.
I guess that makes sense.
That's fine.
At this juncture, I don't intend to conduct a prelim. We just want to make sure, get as much bundled up as we can.
All right, anything else for the record?
Nothing to me.
All right, then we are adjourned, and we may see everybody later on.
I'll see you. Okay?
Yes.
This is the people of the state of Michigan versus Brandon James Wetterman, case number 254416 FY. Appearances, counsel?
Joanna Carey, for the people.
Police Courtroom Champion, appearing on behalf of Mr. Letterman, who is present via Zoom.
Mr. Wetterman, are you able to see and hear me?
Yes, I can see and hear you guys just fine.
All right. Council, I have received the report from the Department of Health and Human Services dated December 22nd. This matter by Dr. Deanne Yount. Have you both received a copy of that?
I did.
We have, Your Honor.
Champion, do you take any exception to the finding?
No, Your Honor.
Ms. Carey?
No.
All right. The finding is that Mr. Wetterman currently is incompetent to stand trial, but believes to be restorable. So the court will go ahead and enter the necessary orders for that. Is there anything else for the record?
No, Your Honor.
All right, we are adjourned.